These trial questions are focused only on the core level 100 courses undertaken in the first semester and are designed to provide the contestants and sundry with an authentic preview of the upcoming quiz. Kindly subscribe to this channel and share as well. Round 1. General knowledge on legal authorities in constitutional law and legal system and method. Question 1. Article 115 of the 1992 Constitution provides that there shall be freedom of speech, debate, and proceedings in Parliament, and that freedom shall not be impeached or questioned in any court or place out of Parliament. Does this mean that A. Members of Parliament cannot be sued for anything they say as members of Parliament in their constituencies? B. Members of Parliament cannot be sued for anything they say on the floor of Parliament? C. Members of Parliament cannot be sued for anything they say anywhere in Ghana for as long as they remain MPs. Or D. Members of Parliament cannot be sued for anything they say within the precincts of Parliament. Answer D. Members of Parliament cannot be sued for anything they say within the precincts of Parliament. Question 2. The case of J.H. Mensah and Attorney General, 1996-1997, held that A. The term of ministers automatically expired with the particular term of the president. B. Ministers who were renominated after serving a first term were not subject to prior parliamentary approval. C. Senior ministers were exempted from parliamentary approval. Or D. Ministers who are also members of Parliament were not subject to parliamentary approval. Answer A. The term of ministers automatically expired with the particular term of president. Question 3. In To For an Attorney General, a specific judge stated, "A constitution such as ours embodies the will of a people. It also mirrors their history. Accounts therefore needs to be taken of it as a landmark in a people's search for progress. It contains within it their aspirations and their hopes for a better and freer life. The Constitution has its letter of the law. Equally, the Constitution has its spirit. Its language must be considered as if it were a living organism capable of growth and development. A broad and liberal spirit is required for its interpretation." Which judge uttered these words? A. Justice Apalu. B. Justice Archer. C. Justice Sowa. Or D. Justice Ansah. Answer C. Justice Sowa. Question 4. The prophecies of what the courts will do in fact and nothing pretentious are what I mean by law. Who made this statement? A. Carl Llewellyn. B. Jerome Frank. C. Oliver Wendell Holmes Jr. Or D. Oliver Cromwell. Answer C. Oliver Wendell Holmes Jr. Question 5. Laws proper or properly so called are commands. Laws which are not commands, improper or improperly so called. Whose idea of law does this statement represent? A. H.L.A. Hart. B. John Austin. C. R.M. Dworkin. Or D. Jeremy Bentham. Answer B. John Austin. Question 6. Name the specific authors who gave the following description to what a legal system is. I. According to ellipsis. A legal system is the body of rules in operation in a particular society at a given time with institutions which go with them. II. Ellipsis, on the other hand, describes the legal system as an operating set of legal institutions, procedures, and rules. III. Ellipsis, all those branches of law which in any given country combine to form its national law. Answer: Simpson, Merriman, David and Briley, respectively. Question 7. Which judge made the following statements on page 535 in the case of Riakoto? In our view, the declaration merely represents the goal which every president must pledge himself to attempt to achieve. The declarations, however, impose on every president a moral obligation and provide a political yardstick by which the conduct of the head of state can be measured by the electorate. The people's remedy for any departure from the principles of the declaration is through the use of ballot box and not through the courts. Answer: Akukosa CJ. Question 8. Which justice of the Supreme Court of Ghana made the following statements in the case of Adjofo and Attorney General? This constitutional provision unequivocally and authoritatively establishes a doctrine of supremacy of the Constitution in the Ghanaian jurisdiction. The doctrine implies that the supremacy of Parliament is limited and that enactments by Parliament and those of previous legislatures are subject to the supremacy of the Constitution. Answer: Dr. Dateba JSC. Question 9. Which judge in the 31st December case made the following statement? In my view, even though Parliament has the right to legislate, this right is not without limit, and the right to enact a law that June 4th and December 31st should be declared public holidays cannot be left to linger in the realm of public policy. Such legislation must be within the parameters of power conferred on the legislature under Article 1(2) of the Constitution. Any law found to be inconsistent with any provision of this Constitution, the supreme law, shall, to the extent of such an inconsistency, be void. Answer: Akins JSC. Question 10. Which judge made the following statement in the 31st December case? Parliament now has no uncontrolled right to pass laws on public holidays, any more than it has to declare a one-party state or make a party leader president for life or crown him emperor. As the fundamental or basic law, the 1992 Constitution controls all legislation and determines their validity. It is for the courts as guardians of legality to ensure that all agencies of the state keep within their lawful bounds. Answer: Amwasechi JSC. Question 11. Which judge made the following statement in Blackburn and Attorney General? Negotiations are still in progress, for us to join the common market. No agreement has been reached. No treaty has been signed. It is elementary that these courts take no notice of treaties as such. We take no notice of treaties until they are embodied in laws enacted by Parliament, and then only to the extent that Parliament tells us. For full facts, see separation of powers. Answer: Lord Denning. Question 12. Which case imported a requirement of a prima facie determination under Article 146 of the Constitution for the removal of the Chief Justice? Answer: A.J. Truman, Attorney General, and Bright Akweti. Question 13. Where under the Constitution of Ghana shall one find this provision? A bill affecting the institution of chieftaincy shall not be introduced in Parliament without prior reference to the National House of Chiefs. Answer: Article 106, Clause 3. Question 14. In which case did Hayfon Benjamin J.A. hold that citizenship once conferred can be lost through processes specifically stated instruments conferring that citizenship and not by ambiguity? Answer: Shalabi and Attorney General. Question 15. Identify the specific judges who made the following statements in the case of NPP and IGP. I. Any law that extends to give authority to any person or persons to prohibit or grant a permit to other persons to take part in procession and demonstrations curtails the freedom of such persons and cannot be said to be justifiable in terms of the spirit of the 1992 Constitution. II. An unfettered discretion is to place those who assert their constitutional right of assembly, procession, and demonstration at the mercy of the police. The Constitution was intended that the citizens of this country should enjoy the fullest measure of responsible human and civil rights. Therefore, any law which seeks to abridge these rights and freedoms must be struck down as unconstitutional. The requirement of a permit or license is one of such abridgments of the constitutional rights. Answer: Justice Akins and Justice Hayford Benjamin, respectively. Question 16. The Crown enters into treaties. Parliament enacts laws, and it is the duty of this court in proper cases to interpret those laws when made, but it is no part of this court's function or duty to make declarations in general terms regarding the powers of Parliament. Whom among these justices made the following dictum under separation of law? A. Denning L.J. B. Salmon L.J. or C. Stamp L.J. Answer: Stamp L.J. Question 17. In which case did His Lordship Edward Ruedu JSC, as he then was, write as follows: The scope and extent of the doctrine of the separation of powers, in my respectful view, and as I understand it under the 1992 Constitution, is to ensure that each arm of state, in the performance of its duties within the framework of the 1992 Constitution, is to act independently and should not be obstructed in the exercise of its legitimate duties or be unduly interfered with by the Constitution. In other words, all arms of the state are answerable or responsible to the 1992 Constitution. It is also to ensure the smooth administration, either judicial, legislative, or executive, governance of the state, whilst checks and balances are provided to ensure strict observance by each arm of state of the provision of the 1992 Constitution. Answer: Ghana Bar Association and Attorney General. Question 18. Name the judge and the case in which the following dictum was first made. While the Constitution diffuses power to secure better liberty, it also contemplates that practice will integrate the dispersed powers into a workable environment. It enjoys upon its branches separateness, but interdependence, autonomy, and reciprocity. Answer: Justice Jackson, in the case of Youngstown Sheet Tube & Co. and Sawyer. Question 19. Pick the odd one out. Supremacy of the Constitution, rule of law, separation of powers, judicial precedence. Answer: Judicial precedence. Round 2. General knowledge on legal principles in constitutional law and legal system and method. Question 1. Which of the following statements does not form part of A.B. Dicey's explanation of the concept of rule of law? A. No man is punishable except for a distinct breach of the law. B. Absolute supremacy of regular law as opposed to the influence of arbitrary power. C. Effective enforcement of fundamental human rights. Or D. Everybody is equal before the law. Answer: B. Absolute supremacy of regular law as opposed to the influence of arbitrary power. Question 2. Which one of the propositions below constitutes an element in a valid will in accordance with the Wills Act 1971? A. A will need not be in writing and may be made orally in the presence of at least one witness. B. The signature of the testator shall be made or acknowledged by the testator in the presence of two or more witnesses present at the same time. C. The signature of the testator shall be made or acknowledged by the testator in the presence of at least one witness. Or D. A will need not be witnessed if all of the beneficiaries under it are present at the time it is signed by the testator. Answer: B. The signature of the testator shall be made or acknowledged by the testator in the presence of two or more witnesses present at the same time. Question 4. Which of the following is not a canon or rule of construction? A. Expressio unius et exclusio ulterius. B. Ut res majoris veliat quam perit. C. Ejusdem generis. Or D. Res ipsa loquiter. Answer: D. res ipsa loquitur. Question 5. The term obiter dictum means A. The legal reason stated by a court as being the basis of its decision. B. The legal reason which, although based on the facts as found by the court, did not form the basis of its decision. C. The legal reason for the finding of material facts, direct or inferential. Or D. The descriptive reasoning adopted by the court in reaching a conclusion. Answer B. The legal reason which, although based on the facts as found by the court, did not form the basis of its decision. Question 6. The golden rule of statutory interpretation allows one of the following things to be done. A. Departure from the plain meaning of the statute. B. Insertion of appropriate words where there is a glaring omission in the statute. C. Enjoins the court to construe the statute so as to suppress the mischief and advance the remedy. Or D. Allows the court to construe a statute in such a way as to give it business efficacy. Answer A. Departure from the plain meaning of the statute. Question 7. What is meant by the doctrine of non-justiciable political question? A. It means that when a matter is exclusively delegated to a branch of government to determine, the other branches cannot determine that matter. B. It means when the question before the court is a political question, the court will decline jurisdiction. C. It means when a decision on a political question will undermine the doctrine of separation of powers, the court will decline jurisdiction. Or D. It means the Constitution being essentially a political document, the court cannot avoid determining political questions. Answer B. It means when the question before the court is a political question, the court will decline jurisdiction. Question 8. In terms of case law, one of the following is not a cause or matter affecting chieftaincy. A. Transmission of chief's declaration form to the National House of Chiefs. B. The recovery or delivery of stolen property in connection with abdication of a chief. C. Constitutional relations and a customary law between chiefs. Or D. The nomination of any person as a chief. Answer A. Transmission of chief's declaration form to the National House of Chiefs. Question 9. Which of the following is not a general principle for constitutional interpretation? A. The Constitution must be given a benevolent, broad, liberal, and purposive construction. B. The Constitution must be construed as a political document capable of growth. C. The court must avoid importing into the Constitution what does not appear therein. Or D. The court may use public policy considerations as a tool for constitutional interpretation. Answer D. The court may use public policy considerations as a tool for constitutional interpretation. Question 10. The English Judicature Acts 1873 to 1875 were of major importance for equity. Which of the following did the Act do? A. Fused the system of common law and equity. B. Gave statutory effect to the rule that equity prevails over the common law. C. Established one court system for both common law and equity. Or D. Allowed any court to deal with both common law and equity. Answer A. Fused the system of common law and equity. Question 11. Which of the following people made this statement? I conceive that land belongs to a vast family of whom many are dead, a few are living, and countless hosts are still unborn. A. Justice Niyama Olenu. B. Nanase Oforiatta. C. John Mensah Saba. Or D. Professor Anselm Klutze. Answer B. Nanase Oforiatta. Question 12. The Supreme Court Ordinance 1876, Section 14, confirmed the received English law that existing on A. 4th of July 1874. B. 1st July 1876. C. 24th July 1874. Or D. 1st January 1876. Answer C. 24th July 1874. Question 13. The Bond of 1844 was primarily designed to achieve the following. A. Protect the signatories from aggression from the Ashanti. B. Protect the signatories from the wrath of the Fanti gods. C. Alliance of the coastal states against the Ashantis. Or D. To extend British dominion over the coastal states of Gold Coast. Answer A. To protect the signatories from aggression from the Ashanti. Question 14. The common law of Ghana consists of the following elements. A. Received English law, doctrines of equity and customary law. B. Received English law, doctrines of equity and rules of natural justice. C. Received English law as at 24th July 1874, customs not repugnant to natural justice, and law of the colonial legislature. Answer A. Received English law, doctrines of equity, and customary law. Question 15. The rule of law in its modern sense owes a great deal to A. Lord Denning. B. Baron de Montesquieu. C. Albert Dicey. Or D. William Blackstone. Answer C. Albert Dicey. Question 16. How many core courses must a student currently pass in order to be eligible for entry into the Ghana School of Law? A. 5. B. 6. C. 7. Or D. 8. Answer B. 6. Round 3. The true or false and alternative round. Law of contract. Question 1. The case of Fisher and Bell, 1961, established the following points of law. A. All adverts in a magazine will constitute an offer to sell. B. A price tag on an item displayed in a shop window must be sold at the displayed price by the retailer. C. An item in a shop window displaying a price tag is generally held as an invitation to treat. Or D. All adverts through the internet are considered offers and are not examples of an invitation to treat. Answer C. An item in a shop window displaying a price tag is generally termed as an invitation to treat. Question 2. In the law of contracts, the display of goods in a shop with price on them is called an invitation to treat. True or false? Answer true. Question 4. As common law, a promise to waive or forgo a debt or past payment of a debt binding on the promisee, or unless there is some fresh consideration flowing from the promisee. Which section of the Contracts Act 1960, Act 25, has modified this rule? A. Section 8(1). B. Section 8(2). C. Section 9. Or D. Section 10. Answer B. Section 8(2). Question 5. Consideration must be adequate and sufficient. True or false? Answer false. Question 6. In law of contracts under Ghanaian law, a minor is a person below 18 years old. True or false? Answer false. Round 4. Riddle. Question Question 1. I am a rule in constitutional law. I could be found in provisions such as Article 23 and 296 of the 1992 Constitution of Ghana. I'm very fundamental in human rights, administrative law, and constitutional law actions. I have the following exceptions to which, if found, one could excuse using me: statutory duty, acquiescence, and necessity. Who am I? Answer: natural justice. Question 2. I am a concept in constitutional law. During an international conference in 1959, the following conditions were agreed in order to have me operationalized: right of a people to representative and responsible government. A citizen who is wronged must have a remedy. Right to a fair and public trial. Respect for the rights and freedoms of others. Independent and impartial judiciary. Independent and courageous legal profession. Control of the administration by the judiciary. Who am I? Answer: rule of law. Question 3. I'm a legal scholar in constitutional law. I define the Constitution as the document in which I set out the rules governing the composition, powers and methods of operation of the main institutions of government, and the general principles defining the relationship between the state and the citizens. Who am I? Answer: Sir Ivor Jennings. Question 4. I was a Justice of the Supreme Court of Ghana during the Third Republic. I quoted St. Paul contained in his first epistle to the Corinthians, chapter 12, verses 14 to 20, King James Version, in a landmark judgment I delivered, and this quote reads as follows: For the body is not one member, but many. If the foot shall say, Because I am not the hand, I am not of the body, is it therefore not of the body? And if the ear shall say, Because I am not the eye, I am not of the body, is it therefore not of the body? If the whole body were an eye, where were the hearing? If the whole were the hearing, where were the smelling? But now are there many members, yet but one body? Who am I? Answer: SOA JSC. Thank you all for watching. Kindly subscribe to this channel as we bring you more content. Turn on your post notifications, like and share.